deal is the biggest scam against the taxpayer in American history. And Americans are going to pay taxes, and Trump and his clan won't.
For millions of Americans following congressional oversight, this exchange between the Senate Finance Committee and the Treasury Department is one you cannot miss. Senator Ron Wyden pressed Secretary Scott Bessent over the sudden halt of presidential tax reviews. Watch what happened when he asked for a direct answer.
So that we understand what's at stake here, this immunity deal is the biggest scam against the taxpayer in American history. And Americans are going to pay taxes, and Trump and his clan won't. So we'll start with that. Now, my second question is, every president's tax return gets audited, Mr. Secretary. Who originated the May 19th addendum canceling Trump's audits? Was it Trump, DOJ, or Treasury?
Again, sir, as Albert Einstein said, doing the same thing and expecting a different answer is the definition of insanity.
That response set the stage for the rest of the hearing. Take a look at the full exchange from the opening moments.
Thank you very much, Mr. Chairman. Secretary, yesterday, Acting Attorney General Todd Blanche indicated that the administration is not moving forward with the slush fund, but there's been no indication of what this means for the Trump alleged IRS audit immunity. So my first question is, does the IRS audit immunity given to Trump, his family, and his businesses still stand? I'd like a yes or no answer to that.
You can answer the question. You can't tell me how to answer it. So, yeah,
I got five minutes. I'm going to use them for these questions.
You're using up your time now, sir. As I said, I am unable to comment with this ongoing litigation.
Okay. So that we understand what's at stake here, this immunity deal is the biggest scam against the taxpayer in American history. And Americans are going to pay taxes, and Trump and his clan won't. So we'll start with that. Now, my second question is, every president's tax return gets audited, Mr. Secretary. Who originated the May 19th addendum canceling Trump's audits? Was it Trump, DOJ, or Treasury?
Again, sir, as Albert Einstein said, doing the same thing and expecting a different answer is the definition of insanity.
Notice what Secretary Bessent just did. He quoted Albert Einstein instead of answering who canceled presidential audits. That is a procedural deflection rather than a substantive answer regarding agency policy. Since Watergate, mandatory audits have guaranteed that no president is above standard tax compliance. Before we continue to the next clip, let us know your thoughts in the comments. Watch what happens as Senator Wyden immediately challenges the Justice Department's authority and a hidden 25-page IRS memo.
You've given no answers on this subject, and that's why I'm going to ask these questions.
And because, as I said, there's ongoing litigation.
Does the DOJ have the authority to settle a tax dispute unilaterally?
The DOJ acts as the attorney for Treasury and the IRS.
So the tax code says the DOJ can only settle a tax dispute if you, the Treasury Secretary, first deferred the dispute to DOJ in the case we're talking about. So here, Trump, his kids, all of the business entities they own, potentially thousands of tax returns, and unless you referred every single one of those tax returns to DOJ, the addendum is invalid, or the Treasury and the IRS believe have been more involved in this scandal, as far as I can tell, than you've led us to believe. So I'm going to keep digging into the timetable here. Career IRS attorneys wrote a 25-page memo preparing defenses against Trump's lawsuit, and they recommended DOJ move to have Trump's lawsuit dismissed. The IRS reportedly gave this memo to Treasury officials in April before the settlement. Did you see that memo?
Again, there's continuing litigation, and I'm unable to answer.
Will you provide this committee with a copy of the IRS memo?
Again, there's continuing litigation.
Bessent's response regarding Department of Justice authority represents a central legal issue in this hearing. He stated that the Justice Department acts as Treasury's attorney. That sounds reasonable until you understand what Wyden was pointing at. Under the Internal Revenue Code, the DOJ cannot settle a tax dispute on its own. A formal referral from the Treasury Secretary is not a formality, but a strict legal prerequisite. Without it, any settlement is legally hollow. Bessent simply restated the standard institutional role of the agency, rather than answering whether that referral ever occurred or whether he reviewed the 25-page IRS defense memo. Before we move to the next clip, share your perspective in the comments on this legal dispute. Watch what happens as Wyden exposes major government contracts canceled just 3 days before a lawsuit was filed.
Mr. Chairman, I'm going to continue my questions, but I would like to ask you now to authorize the 6103 waiver and for Mr. Bessent to waive the attorney-client privilege, which I guess is part of what he's up to.
I will not, I'm not quite sure what you're asking, but I will not agree to ask him to waive his attorney-client privilege.
So the way we're going to get to the bottom of it is to have the committee look at these matters in a bipartisan way, and I'm just going to continue with the questions that highlight my argument. The Biden administration prosecuted Charles Littlejohn, the Booz Allen contractor who leaked Trump's tax returns. Booz Allen, which helped with the prosecution, held contracts with the Treasury Department for years. 3 days before Trump filed his lawsuit this year, you abruptly canceled all the contracts. It is hard to see that timing be a coincidence. Did you know in advance that Trump was going to file a suit against the IRS?
I did not.
All right, I've written to you twice asking for records related to this decision. Both times you refused. I'll ask again. Will you send the committee all records documenting this decision so we can review this in a bipartisan fashion?
Again, there is ongoing litigation, and Senator, how we got here was a violation of President Trump's 6103 rights. And it wasn't just President Trump. There were 400,000 tax returns that were leaked by Mr. Littlejohn. And I will point out that Mr. Littlejohn was not prosecuted to the fullest extent of the law. He was eligible to be prosecuted on 3 counts. The Biden administration chose light touch and only prosecuted him on 2 counts.
That pivot by Secretary Bessent at the end deserves its own spotlight. When asked why Treasury abruptly canceled all contracts with Booz Allen just 3 days before a lawsuit was filed, he did not address the timing. Instead, he turned the focus to the prosecution of Charles Littlejohn and the leak of 400,000 tax records. Booz Allen is one of the nation's largest government contractors and had actively cooperated with that federal prosecution. Canceling all of their agency contracts days before litigation began raises serious questions about the official timeline that remain unanswered. Before we move to the final exchange, let us know your thoughts in the comments below. Watch what happens as Senator Wyden delivers his closing remarks, demanding a full 6103 waiver to get the unredacted facts.
We're going to continue these questions, and I come back to my point, Mr. Chairman. We need you to support this 6103 waiver so that this committee on a bipartisan basis can look into a matter like this. When you're talking about the President of the United States, it doesn't get any more important. And I'll just close my opening effort to try to ferret out the facts here, Mr. Chairman, by saying, Mr. Secretary, this whole settlement, in my view, is the most brazen abuse of power ever in our history. And as of now, every American is subject to audit except Donald Trump and his family. I think that's absurd, and you've been dodging questions. Each one of these, you had a legal argument for saying nothing. And I suspect you cleared the way for Trump's lawsuit when you canceled the contracts, and I suspect people right up to the highest level of the Treasury Department had a hand in crafting this unbelievably corrupt gift of a settlement. And I just want it understood, colleagues, I want to work with every senator on this committee to get to the bottom of this, because we aren't getting the facts. And the Secretary, in spite of the fact that he owes answers to the American people, is just dodging and bobbing.
With that single phrase repeated on the Senate record, Treasury Secretary Bessent concluded a hearing that leaves fundamental questions unanswered. When cabinet officials testify under oath before the Senate Finance Committee, their statements do not just determine the outcome of a hearing. They define how federal laws are administered for over 160 million American taxpayers. Across the country, everyday working families and seniors on fixed incomes have their federal taxes withheld automatically before their paychecks or retirement benefits ever reach their accounts. Regular citizens cannot cite legal privilege or point to ongoing litigation when the IRS conducts a standard review of their finances. The system operates on one essential premise: that the tax code applies equally to every citizen, regardless of rank or position. When formal inquiries regarding a concealed 25-page IRS defense memo terminated government contracts, and presidential audit exemptions are met with silence, that basic public trust is tested. Senator Wyden placed these documented questions directly into the permanent congressional record to ensure they remain open for scrutiny. Let's examine what is specifically on the table and why each piece carries serious weight for every American. The 6103 waiver he keeps asking for is not a procedural formality. Section 6103 of the Internal Revenue Code is the law that makes your tax return confidential. It is one of the most tightly protected categories of government information in existence. To breach that confidentiality, even for a congressional investigation, requires a formal waiver. Wyden is asking the committee to formally vote to release those confidential records. Chairman Crapo refused. That refusal will be part of the record of this hearing. Let's examine the substance of Wyden's formal accusation. He stated his suspicion that the Treasury Secretary personally cleared the way for the recent lawsuit by canceling the Booz Allen contracts. He said he suspects that people at the highest levels of Treasury helped craft the settlement. He did not say he had proof of either. He said he suspects. That distinction is important. What he was doing was putting those suspicions into the congressional record, which is not the same as proving them, but it is also not the same as letting them disappear into a news cycle. In congressional oversight, formal concerns entered into the record remain accessible in committee archives for future investigators, legal experts, and journalists. When Wyden indicates the inquiry will continue, it signals that standard procedural mechanisms, including formal subpoenas, written document demands, and follow-up hearings, remain actively available under Senate rules. Bessent's consistent answer throughout this entire exchange was the phrase ongoing litigation. While citing ongoing litigation is a standard procedural defense, it is not an absolute shield against congressional oversight. Ongoing litigation is a legitimate reason for a witness to decline answering in some contexts. It is not a blanket protection. Courts can and do compel testimony from witnesses even when related litigation is pending. The question is whether anyone in the Senate is willing to push hard enough to get there. The mandatory presidential audit program, which Wyden argues was effectively dismantled by the May 19th addendum, was put in place by Congress in the 1970s. It was a direct response to the disclosure that President Nixon had improperly used the IRS as a political tool and had himself underpaid his taxes by a significant amount. Nixon famously declared to the American people that he was not a crook. The audit program was designed so that no future president would have to make that declaration, because there would be an independent, ongoing record of their compliance. The program was created specifically as an ongoing transparency safeguard rather than a punitive rule. If the May 19th addendum did what Wyden says it did, and the facts he cited in this hearing suggest it may have, then the protection built after Nixon is no longer functioning for this presidency. This raises immediate questions about whether a critical institutional safeguard remains intact. Bessent's pivot to the Little John prosecution in his final answer also deserves a second look. He said Little John was eligible for 3 counts, but was only prosecuted on 2. That is factually accurate. Little John pleaded guilty to 1 count of unauthorized disclosure of tax return information and was sentenced to 5 years in prison. Bessent is correct that additional charges could have been pursued. However, the broader context of that sentencing tells a different story. The prosecutor who handled the Little John case said at sentencing that the 5-year sentence, the maximum available on the charge brought, was appropriate given the scale of the offense. The decision to bring 1 count rather than 3 was a prosecutorial judgment, not leniency. Booz Allen actively assisted federal investigators during that case, which is why the abrupt termination of their Treasury contracts continues to draw scrutiny. Ultimately, this testimony centers on a fundamental question: whether the agency responsible for administering federal revenue laws remains subject to independent congressional oversight across all levels of government. What unfolded in the Senate today reflects a profound debate over constitutional checks and balances. When career legal guidance is withheld and formal requests for documentation are repeatedly declined, it leaves the official record incomplete and public accountability in question. Where do you stand on this exchange? Should Congress have full access to internal agency records during an inquiry? Or should executive departments maintain legal privilege? Share your perspective in the comments below. If you appreciate direct, evidence-based reporting on the work of our government, please like the video and subscribe to the Politics Report. Thanks for watching.